Hey there, welcome to another video today. Today I'm going to talk about what actually happens when you file for bankruptcy. What happens at the 341 meeting of creditors. You've heard that term 100 times before, and for all the research you're doing online, you've seen it on my blog post 165 times. So let's actually get into the meat of what this really means and how it affects you. So the first thing I want you to really understand is just that. This is not your normal hearing. Whatever you've seen on TV where the lawyers are being adversarial and then the witness looks bad and the witness has his contradiction and this whole trial is condensed into 10 minutes and you're like, all right, this is awesome. I love this show. That's not how it works at a 341 meeting. Everything I just said is the complete opposite of what happens in reality at these hearings. The first thing I want you to understand is there's no judge. Judge is strictly prohibited from attending the 341 meeting of creditors. So the judge is not going to be there issuing rulings, telling the witness, you're going to be held in contempt. None of that happens. It's great TV. Court drama has nothing to do with bankruptcy. So you can forget the judge being there right off the top. Number two, jury. There is no jury. No one is going to be there. I'm exaggerating. You know who's going to be there? The bankruptcy trustee, right? Person who gets assigned immediately to the case. And it is called the meeting of creditors. So I'm sure a bunch of creditors are going to show up and give you a hard time and say all these negative things about you. You don't have to worry about that either. It is called the meeting of creditors because creditors could appear, but guess what? They don't. There's nothing that really goes on at the 341 meeting of creditors. You're talking about the bankruptcy trustee, and the bankruptcy trustee can't issue rulings. The bankruptcy trustee can't say, I'm going to deny your bankruptcy. They could say they're going to make a recommendation to deny your bankruptcy or a recommendation to the judge to approve it, but they don't have that authority. It's the judge who has it at the end of the day. So, even though it's called the meeting of creditors, what are the creditors going to do there? Are they allowed to ask questions? Sure. By the way, again, they rarely show up. Who typically shows up is a person, an individual you owe money to, and because they don't know any better, they show up and they think they're going to be able to ask questions for half an hour, and it doesn't work that way. If your 341 meeting lasts more than 2 to 5 minutes, I'd be surprised. It's probably a very slow trustee, unless there's something extremely complicated about your case or new information comes up. But the reality is, even so many years in Miami, I had developed relationships with these trustees. Sometimes they didn't ask any questions. I have to be honest. They would just say, the debtor's attorney make an appearance. I would say Alex Hernandez on behalf of the debtor. Trustee would say, are there any creditors present? And they were done. But that's a working relationship for decades, and so I got away with that. But your normal case, 2 to 5 minutes, not much is going on there. So that a creditor appears, typically an individual, they're going to ask questions. The trustee is going to say, if you have an issue, file a 2004 examination, kind of like a deposition. If you want to object to the discharge of the debt, they would file an adversary. And we'll go all over that. But I did write a blog post on Rudy Giuliani, the former mayor. I've actually written several blog posts about him. He went through the 2004 examination, and now ultimately the next step would have been an adversary proceeding to object to the discharge of the defamation lawsuit. Fast forward, his case was dismissed. He agreed, so none of that applies. But that would have been the next step: objecting to the discharge, which a creditor could do. Is it going to happen in your typical case? No. But if you spend $10,000 today and you're filing bankruptcy tomorrow, yeah, there's going to be an objection to the discharge of that debt. Now, what else happens at this hearing? Well, first place, where is it? There's no judge, I said. There's no jury, right? What does that mean? Could be anywhere. Really just depends where you are. If you're in the District of Colorado, which only has one district, one bankruptcy court, depends where you live. They're not going to make you drive 300 miles north or south to get to the hearing. It'll probably be, I know, actually, that's Farmington. Farmington, New Mexico has the 341 meetings at a university. I think in Colorado Springs, it's held like at City Hall. Some places might be the trustee's office. Of course, these are smaller districts and everything else. If you're in Miami, Jacksonville, these large cities, it's going to be at the courthouse, but it's a separate room. Because why? Because the judge can't be there. Now, this is very important. please, please, please take your driver's license and social security card, original social security card, if you want to save money. Why do I save money? What's the connection? Because if your lawyer has to go to another hearing because you did not bring those two items, those two forms of ID, and you were told, they're going to charge you to go to the next hearing again. Okay, so that's just it is. We bill for our time, no different than you. And if we have to go to another hearing, we will. It's going to cost you anywhere from another 150 to another $500. So keep that in mind. I know you're nervous, you're stressed out, but I'm here to tell you it's not a big deal. These 341 meetings are actually pretty laid back. My first suggestion, get there early. Nowadays, it's being done remotely. It's done by phone, but a trustee could still say, I want everybody to come in. If that's the case, then just go so you can see the atmosphere or dial in. The information that you get on your bankruptcy that says, here's the code to get in is going to be the same code for the same trustee. Try to listen in on other hearings. It could be another trustee. It doesn't really matter. They all pretty much ask the same question. And there is a blog post that I did. I'll post that at the bottom um, of this video that shows you the questions that you can expect to be asked at the 341 hearing. I'm not going to go into those details, but do check out that blog post, okay? But you have to take your original DL and Social Security card, the photo of your driver's license, your Social Security card. That ain't going to fly. Your tax returns, it's not going to fly. They need the original. Who carries originals with them these days? Nobody. I remember doing that like I don't know, after college for whatever reason. I had my social security card, like I needed that in case some emergency job was gonna. It's just the whole thing's ridiculous. But hey, back in the day, that's how we did it. So don't make fun of us, you younger people. Now the questions that are asked, I'll go over the basics. They're really just there to reinforce everything that's been submitted in the petition. So they're going to ask if you signed it freely and voluntarily. Did you understand it? Me being in Miami, I had a lot of clients that only spoke Spanish or Spanish was their predominant language. And the trustee is going to say, if there's a translator there, they're going to say, did your lawyer translate this from English to Spanish for you? So that's another typical question you can ask. They're going to ask if does anybody owe you money? Because if you say, yes, my uncle owes me $10,000, the trustee is going to go after your uncle for the $10,000. That's part of the bankruptcy estate. Did you list any creditor? Do you need to make any changes? Did you do this freely and voluntarily? Those are the typical questions that are asked. Again, I did a separate blog post on that. You're able to look into that into more detail just to see the questions, and I kind of put like a point and counterpoint, but you have an idea of what goes on there. It's not really, this is what I really want you to understand. It's not the typical, I mean, even if you've been through, divorce court, criminal cases, whatever it might be, where you see that adversarial type process, this is not it. The trustee represents the bankruptcy estate. The overwhelming majority of trustees are nice people. They're very calm. They're very relaxed. There are exceptions. I've had to deal with a few in my life. But you will see that it is a completely different process, and that should put you at ease. All right, so calm down. Right, namaste. Right, just take a deep breath, relax. If you're doing this remotely, burn some scented candles, do incense, do whatever you got to do to calm yourself down. You'll see you'll be all right. Okay, so any questions, as always, feel free to post them in the comment section below. Look out for those two blog posts that I've referenced, especially the specific questions you're expected to be asked. Doesn't matter what district you're in, what city you're in, what county you're in. It's basically the same questions for everybody. Remember, federal law is throughout the U.S. It's not state law. If you live in Florida, only state law applies to A, B, and C. This is federal law, so it's going to be consistent throughout. Okay, take care, everyone. I'll see you at the next video. Any comments? Feel free to reach out to me. Don't be embarrassed. Hit me up on social media. Take care, everybody.